Okay, I think we will get started. There's a few people coming through the door, but it's time now, so we'll get going in this session. Thank you everybody for joining, both in person and online, in this session where we're going to look at the national contact points for responsible business conduct and the role that they play in achieving access to remedy in the region. My name is Kate Wilson, and I am the project manager for Asia for the OECD Centre for Responsible Business Conduct, and I'll be moderating today's discussion. And before we begin, I wanted to let you know that there's Bahasa Indonesian available on the headsets in the room, and if that's helpful for you. So what we really want to achieve with the session today is to demystify the process of going through a specific instance or complaint to a national contact point for responsible business conduct, both for notifiers or complainants and for companies who find themselves subject to a complaint. National contact points are an important option in the remedy landscape in Asia Pacific. In fact, 25% of the complaints submitted to national contact points around the world relate to operations and activities in the region. However, the mechanism is not always on the radar for potential notifiers for complaints, and there's scope for better understanding across all stakeholders about the sorts of circumstances that are necessary for a complaint to meet the eligibility criteria for an NCP. So before we begin and I introduce our speakers, I will briefly recap what national contact points for responsible business conduct are and mention some of the terms that we'll use to make it easier to follow the discussion. Firstly, national contact points are often referred to as NCPs, and there are 52 NCPs around the world. These are in the 38 OECD member countries, as well as 14 non-member countries that have gone through the necessary steps to adhere to the relevant OECD declaration. NCPs are the implementation mechanism of the OECD guidelines for multinational enterprises on responsible business conduct. And these guidelines were first developed in 1976 and most recently updated in 2023. The guidelines are a set of recommendations for business covering all aspects or areas of business responsibility. So this is labour and human rights, environment, disclosure, anti-corruption, consumer interests, science and technology, competition, and taxation. So the guidelines are aligned with and complement the UN Guiding Principles on Business and Human Rights and the ILO M&E Declaration. But as you just heard, the topics are broader than just human rights and labour rights. There are a set of voluntary recommendations for business. However, every country adhering to the OECD guidelines has a legal obligation to establish an NCP. And one part of the responsibilities of an NCP is to act as a non-judicial grievance mechanism for alleged breaches of the OECD M&E guidelines by companies. Specific instances is the term for complaints or cases that are submitted to NCPs. And the important point I want to emphasise up front today is that NCPs can receive complaints in relation to multinational enterprises operating in or from the country that adheres to the guidelines. So for example, the NCP in New Zealand can receive complaints about a company headquartered in New Zealand with operations in Malaysia or any country around the world. It can also receive complaints about a multinational enterprise operating in New Zealand, so an overseas company operating in New Zealand, just to explain the jurisdiction of each NCP, and it relates to where the alleged harms have occurred and where the multinational enterprise is based. That's why we see many NCP complaints in countries that are not adherents to the guidelines, because in those cases, it's been about the conduct of companies headquartered in adherent countries. So today we have the privilege of hearing from 3 speakers with different perspectives on the NCP specific instance process. Our first speaker is Professor Soo-yeon Lee, who is an academic researcher with particular expertise in labour law, and she serves as a commissioner on the Korean National Contact Point for Responsible Business Conduct, and is one of 4 non-government or civilian commissioners who serve on the NCP. There are also 4 government commissioners on the Korean NCP, and the Korean NCP is chaired by the Ministry of Trade, Industry and Energy. So I wanted to start today by asking Soo-yeon if you can please explain the process that occurs when the Korean NCP receives a specific instance, and also if you can tell us about any of the measures in place to help make that process accessible to organizations and individuals submitting complaints.
Thank you, Kate, and thank you, organizers. I'm really honored for the opportunity to speak here today. Let me answer your question. What the process when the Korea NCP receives specific instance? As Kate mentioned already, NCPs perform important functions and roles related to compliance with OECD guidelines. Mainly, NCPs promote the guidelines and policy coherence, as well as determine whether enterprises are breaching the guidelines. If there is a breach, the NCP recommends remedy. The Korea NCP is the same. We deal with complaints based on fairness, transparency, convenience, expertise, and the free provision of services. First of all, for example, someone files complaint to the Korea NCP, then we consider, is there any countries NCP involved? If multiple NCPs are involved, we must decide who will play the primary role and who will play the supporting role. Then the parties are asked to exchange their opinion in writing. We usually do this at least twice. Korea NCP operates secretariat and standing committee and the mediation committee. The standing committee conduct the first round evaluation. We determine whether the case continues or should be dismissed. We continue, good offices are provided to both parties. It is important for the counterparty to participate because it can encourage the enterprises to voluntarily comply with the OECD guidelines. The good offices period recommended by the guidelines is 1 year. Sometimes it takes longer, depending on the parties requested only. If good offices are not settled, the standing committee conduct a final evaluation, and the decision is made on whether to make a recommendation. The final statement is reported to the government and the OECD. It is also made public on the Korea NCP website. Then we keep watch and monitor the company's compliance with the OECD guidelines. And the second one is, do we have measures to make a process accessible? Yes, we do. We have regulations and procedural rules. We have a website, we have a YouTube account, and we offers online or offline meetings. Our secretariat is fluent Korean and English. Materials and services are provided in Korean and English. Many other services we provide that makes it easy for you to access us, but much of these are, you could see our website, I think. So I will skip here. But however, there is one more thing I want to mention. Korea has a judicial system and also various administrative dispute resolution system. They have authority to impose correction action orders and administrative penalties for redress various rights, like such as human rights. In my opinion, the system is working really well, and also it's improving continuously. However, the NCP does not have such authority. It can only make recommendations. Nevertheless, the Korea NCP has received cases continuously. We have been performing faithfully our role of bridging the gaps that the judicial and administrative remedy system are unable to fulfill. So more and more, the public is aware of the NCP and the OECD guidelines, I think. Thanks.
Thank you, and thank you very much, Professor Lee. And can you also tell us about the types of human rights grievances that communities and organizations have brought to NCPs in the past, to give everybody a sense of those, and what makes the NCP unique in dealing with those?
Okay. At the beginning, and Kate mentioned already, NCPs have handled various cases. Last 24 years, as the complaints relating to human rights issues in sugar production in Cambodia, sexual harassment, and the working conditions in the sales service section in Korea, and human rights and the environmental impact of mining investment in Papua New Guinea, and the adverse impact from investment in various sectors in Myanmar and Indonesia. Those complaints are filed by individuals, NGOs, and trade unions, domestically or internationally. Sometimes they come from a country with an NCP, and sometimes not. Past cases seem to have dealt with adverse impact more in the environment rather than human rights. And also, those cases show direct infringement of domestic laws, rather than enterprises' breach of due diligence complying with OECD guidelines. In the future, I hope more of cases related to adverse impact and due diligence are brought to our attention. Another thing we need to know about is the supply chain characteristics of this region, Asia Pacific. There are 53 UN members and about 60% of the world population in this region. Many multinational enterprises are conducting business activities in manufacturing and resource extraction. However, there are only 4 OECD members in this region: Korea, Japan, Australia, and New Zealand. Kazakhstan also has NCP, even though Asian countries that experience adverse impact likely do not have domestic NCPs or related remedy systems. So how should people in the Asia-Pacific region without NCPs receive the remedy? Think about the supply chain. What country is the investor or company coming from? That, I think, would be really important. And your question about how NCPs are distinguished from other judicial and non-judicial redress mechanisms, I'll give you 4 examples. In my opinion, first, there is a principle of free provision of NCP services. That is one. Most NCP services are provided for free. And second, NCPs help establish human rights standards across borders. Most countries do not explicitly legislate due diligence obligation on human rights to comply with the guidelines. Most cases, when going through a dispute resolution based on domestic laws, the effect of decision are only applied to companies and citizens domestically. However, Procedure through the NCP enhances the application and the promotion of the guidelines across borders. So cases through the NCPs contribute to global standardization, I think. And third, NCPs expand the scope of the parties filing a complaint. Anyone can file a complaint to the NCP, even if you are the person, NGOs, or labor union, or other stakeholders residing abroad. You can file a complaint to the NCP. So fourth, NCP is the burden of proof. Normally, in a lawsuit, it is the plaintiff that bears the burden of proof. The NCP effectively is the burden of proof because the NCP takes the lead in conducting evaluation of the specific instance. So I think it's what makes the NCPs unique. It's all of the above make NCPs unique. Thank you.
Thank you. And I think that was that cross-border, the nature of cross-border issues that can happen in different jurisdictions is a really good one to emphasize and is a space where the NCPs are particularly valuable. I'm now going to turn to Sarah McGrath, who is a director at Pillar 2, which is a specialist business and human rights advisory firm. Pillar 2 is one of the organisations representing business on the governance and advisory board of the Australian National Contact Point. So along with civil society, trade union and government representatives, the business representatives on the Australian NCP board bring essential perspectives to all aspects of the NCP's work, including the management of complaints. So my first question for Sarah is, what are some of the examples of the types of outcomes that can be achieved through the NCP mechanism? And what are some of the steps NCPs take to try and facilitate access to achieve that?
Great, thank you so much, Kate, and such an honour to be here on this panel to discuss the role of NCPs. So as we heard from Professor Lee, NCPs are not courts and they can't impose penalties or require companies to participate in the NCP process or require remediation. But what they can offer is they're good officers to seek to facilitate an agreement, and that is done through a process of mediation or conciliation. So in practice, NCPs can achieve, have been able to facilitate remedies such as financial compensation, acknowledgement of inadequate practices, in-kind reparations, and changes to policies and practices and procedures. Sometimes agreements are confidential, so we also don't know the specifics of the outcomes of the agreements and what has been achieved there. While this is what can be achieved, I think the work that OECD Watch and others do to track and monitor the outcomes of NCP processes demonstrate that the types of outcomes are not necessarily common practice across the board globally. In Australia, we've had some interesting outcomes in some particular cases. We had one case where the examiner actually also made a recommendation to the Australian government. So in the final statement, there was a recommendation that the Australian government give further guidance for companies that are operating overseas, particularly in relation to areas of heightened risk and including conflict-affected areas. Also in Australia, regardless of whether good officers are accepted, the Australian NCP can also make determinations in relation to breaches of the OECD guidelines, and will put that in its final statement. And I know that's not the case for every NCP. I believe it is in the context of Korea as well. So even, at least in the Australian context, even where a company does not participate in that process, we'll still see if the specific instances accepted and moved through the process, an analysis in relation to practice in terms of compliance with the OECD guidelines. Sometimes we also see agreements take place outside of the NCP formal process, which I think is interesting because it shows that while the discussions may move away from the formal NCP vehicle, it does still provide a platform to bring parties together, potentially build some of those bridges, or also put a bit of pressure on companies to seek to find an agreement outside of the formal NCP process. In terms of your question around accessibility, I think that's been a really consistent theme over the last couple of days, and NCPs are definitely not immune to that challenge, and it's also one of the core criteria for NCPs. And in the Australian context, the Australian NCP updated its complaint procedures in April of this year. And it acknowledges some of the accessibility challenges in relation to language, culture, accessibility with technology, and also some of the challenges in relation to notifiers being overseas and some of the geographical challenges that may place. So the Australian NCP, through its complaint procedures, has committed to taking reasonable steps to help facilitate notifiers increase their accessibility to the AusNCP, and that can happen in a number of ways. One is around using various technology services, whether it's through document sharing platforms that are secure, whether it's through providing online mediation and conciliation services. Interestingly, there's also in the complaint procedure an offer to use Australian missions overseas to see how they could help notifiers in other countries participate in the NCP process. And there's also translation services. So we did see in one case the executive summary of a complaint translated into Burmese for notifiers that were based in Myanmar, and that was made publicly available on the AusNCP's website. Where there might be challenges for NCPs to, notifiers to make a complaint through the online system, and again, if there's any barriers in relation to using technology or having access to the internet, the NCP, through its complaint procedure, can also look to connect the notifier with other third parties who might be able to assist and facilitate that process. And just one final comment on accessibility, because I think it's really important. The Australian procedures also take into consideration where there might be risk to safety or harm for a notifier, or any potential risks around threats or reprisals, and also allows for anonymous complaints to be made via third parties as well.
Thanks, Sarah. These are really, really good examples there, and I think hopefully giving some encouragement and demonstrating that that it doesn't need to be an international NGO using English who needs to be submitting complaints. There's a real emphasis from NCPs to try and facilitate access to people with who don't have that necessarily have that on hand. My next question is one that goes to this this question of business engagement in the process, because it's in order for there to be mediation, there needs to be two parties to agree to have to use NCP's mediation or good officers services. So this question I'd like to ask Sarah is, what advice would you give to a company that's subject to a specific instance and how they should handle that situation?
Thanks, Kate. I think the first piece of advice is you don't want your company learning about NCPs for the first time when a specific instance comes in, because there's a lot of background work and prep that needs to happen at that point in time. So I think starting to think about NCPs now, starting to understand the OECD guidelines, starting to, if you are in a country that has an NCP, understand its procedures and processes, and also look for opportunities to brief your leadership team or your board where appropriate as well. So you're starting to build that organisational capacity and knowledge and understanding around the NCP process. In terms of the mediation process, it is a resource-intensive exercise to participate meaningfully and properly, and so making sure that it is adequately resourced and you've got the right expertise and knowledge at the table, including people with human rights knowledge and expertise, and not necessarily leaving it to the lawyers alone. While it can be a resource-intensive process, when you consider it to going through legal channels or litigations, I think when you compare it in relation to cost or protracted legal processes, it is quite less intensive from that perspective. So I think it's important to keep that in mind, and if a specific incident comes in, not to have a knee-jerk reaction to that. I think the other recommendation is around not coming from a defensive position, so using it as an opportunity to learn, to understand where there might be gaps in your policies and processes and procedures and practices. And obviously it will vary depending on what the specific instance is in relation to, but there might be opportunities to understand where there's opportunity for increased stakeholder engagement, strengthening your due diligence processes or your grievance channels. I think as well, when responding to a specific instance and engaging in the process, keeping in mind the commitments that you've made as a company to those international standards, whether it's the UNGPs or the OECD guidelines, as you engage in these processes and the final statements are made publicly available to everybody, you wouldn't want any external stakeholders to be looking at those final statements and comparing them to the commitments that you've made in your human rights policy or other documents. So I think just keeping in mind the commitments that you've made to international global standards. And then finally, particularly in the Australian context, as I mentioned, if a company doesn't engage in the process or accept the offer of good offices, the NCP still can go through the determination process and include that in its final statement. So there's a reputational risk of not participating in the process, not having an opportunity to explain why something was done, and really just stepping away from it and seeing how the process plays out. So there's a real, I think, reputational risk there for companies as well.
Thank you. And so now we will turn to Linda. Linda Rosalina is the Executive Director of TUK Indonesia, and over the past decade, TUK Indonesia has submitted 2 specific instance complaints to the National Contact Point for Responsible Business Conduct in Switzerland. In relation to palm oil production and land use for a cement factory in Indonesia. Linda has a big ask today because she's representing, giving the perspective of the notifier, notifying organisation, which is a really important perspective. And so we're asking a lot of you. But my first question to you, Linda, is if you could briefly describe the complaint your organisation brought to the Swiss NCP in 2018 and how it works in practice for an organisation to submit a complaint to a mechanism on the other side of the world.
Yeah, thank you, Kate. I'm delighted to have the opportunity to share our experience with you all. And good afternoon, everyone. My name is Linda. I represent Transformasi untuk Keadilan Indonesia, TUK Indonesia, a non-governmental organization dedicated to promoting human rights, advancing social justice, and protecting the environment, particularly in the context of natural resource management. And our work involves extensive monitoring of business sector and financial institutions with specific focus in investing on palm oil and pulp and paper plantation industries. And I would like to request permission to share updates on the progress of this case following our complaint to the NCP, National Contact Point, as this information is important given that case is still ongoing. This case involves land grabbing experienced by the Dayak Hibun indigenous communities of Krunang and Entapang in Sanggau Regency, West Kalimantan, Indonesia. The issue arose due to the presence of PT Mitra Austral Sejahtera, a palm oil company that was at the time owned by the Sime Darby Group, a major Malaysian corporation. The case dates back to 1995 when the company first initiated socialization efforts, and it remains unresolved to this day. At the time, Indonesian national policy were not favorable or conducive to resolving the issue. As a result, in 2012, the Dayak Hibun indigenous communities of Krunang and Entapang opted to use the RSPO, Roundtable on Sustainable Palm Oil mechanism, to seek resolution for their case. The RSPO, Roundtable on Sustainable Palm Oil, is a global organization that promotes sustainable palm oil production through a certification process. When we think of sustainable certification, it implies palm oil that is socially responsible, environmentally friendly, and does not harm communities or ecosystem. This certification is awarded to producers to meet the sustainability standard set by the RSPO, and Sime Darby, as a member of the RSPO, has also received sustainability certification from the organization. And this complaint was filed to highlight that Sime Darby is not fully committed to upholding the RSPO standard. Key principles and criteria such as free, prior, and informed consent, FPIC, and respect for human rights have not been properly implemented. 6 years passed from the initial complaint to the RSPO in 2012 until 2018 with no significant progress. During this process, it became clear that the issue extends beyond Sime Darby. The RSPO itself has also failed to enforce its own standard. These failures include, first, inadequately preventing or mitigating human rights violations, and the second, failing to conduct proper human rights due diligence, and the third, handling the case in an excessively protracted manner. Therefore, we believe there is a need to apply greater pressure on the RSPO to take meaningful action. Upon investigation, we found that the RSPO is a legal entity registered in Switzerland, which led us to explore the opportunity under the OECD framework. In 2018, we submitted the complaint to the Swiss National Contact Point, NCP, seeking their support in facilitating the development of an action plan between RSPO and us to Indonesia and the Dayak Hibun, Krunang, and Entapang indigenous people to address that ongoing RSPO complaint settlement. Did we file a complaint directly to the OECD? No, we did not. Before taking the step, we conducted extensive consultation and training session with the affected indigenous communities to familiarize them with the OECD mechanism. To this approach was informed by our previous experience, with the OECD complaint process in 2015 Holcim case. We also engaged with our international network to better understand and navigate to the OECD mechanism. In 2018, we submitted the complaint to the Swiss NCP. After a year of proceeding in 2019, the Swiss NCP issued a final statement which included an agreement outlining criteria for a fair legal review by the RSPO, as well as an action plan with clear deadline.
Thank you. And so my follow-up to that is, what would you say some of the benefits for this process and for your organization of using the NCP mechanism are, and also what are some of the limitations?
Regarding the answer to the second question, we found the complaint process with the Swiss NCP and its recommendation to be quite beneficial. Here's why. First, at the time, we held a strong bargaining position that encouraged the RSPO to work towards resolving the community complaints. And the second, a mutual agreement was reached, which included the commitment for the RSPO to conduct a legal review. Unfortunately, the outcome of the legal review was misinterpreted by the RSPO, who used it to unilaterally and incorrectly assess the evidence provided by the community regarding the Rasa customary law. The RSPO interpreted this as evidence of the release of land rights. However, our discussion with the indigenous community in Sanggau Regency clarified that the Rasa has a single meaning. The Rasa is a borrow to use right, not a release land right. Due to the RSPO action that exceeds its authority and its potentially misleading interpretation of customary law, representative of the Dayak Hibun indigenous communities in Krunang and Entapang, supported by 21 customary leaders in Sanggau, submitted a formal notice to the RSPO. They believe that the RSPO has harassed and defamed the Dayak Hibun customary law concerning the Derasa custom, which remains alive, valid, and respected by the Dayak Hibun indigenous people. During the complaint process with the Swiss NCP in 2018, we identified several key lessons learned. First, we faced language challenges. The second, we encountered difficulties in identifying a facilitator or mediator who could arrange face-to-face meetings to explain the case and present evidence. Due to our experience with NCP Swiss, the mediation was online. And the third, the NCP should take a proactive role in monitoring the outcomes of agreement. We believe it could be beneficial for the NCP to have a dedicated desk at each embassy to enhance accessibility and support. Furthermore, in today's context, we have noticed that discussion about OECD are relatively scarce in Indonesia. Despite the recent updates to the guideline for multinational enterprises on responsible business conduct in 2023. Therefore, socialization and training on this mechanism are essential, particularly in conflict-affected area.
Thank you, Linda. That's very, very helpful to hear, I think, both in the room and online. I have a third question for all three of the panelists before we go to questions from the audience. And it is, first I'll ask Sarah to answer first. It's, what advice would you give potential notifiers who are considering using an NCP as a means of seeking remedy? What sorts of things should they be aware of before embarking on the process?
Thanks, Kate. I wanted to pick up on one of those points that Linda made in relation to tapping into international networks. And I think the first suggestion would be if you're a notifier looking to bring a specific instance in a country that's not your own, see if there's an opportunity to partner with a local NGO or other organisation that's on the ground and perhaps has easier access to the company on a day-to-day business. It may overcome some of those language barriers and also understands the kind of operating context, and including drivers for the business in relation to the complaint. The other suggestion is, I think, like any other grievance mechanism, really thinking about any potential risks, as I already touched on before, in relation to the notifier's safety or any threats or risks around potential reprisals, and just think through that and whether there are any special requests that might need to be made to the NCP in relation to keeping some information confidential. And then just my final point is around preparing the specific instance. I think, the work that OECD Watch has done has shown that although it's growing, a number of specific instances don't make it past that initial assessment stage. So I think being really clear and precise when drafting the complaint, align it very clearly to the OECD guidelines and be as specific as possible. And again, that's potentially where tapping into international networks and other NGOs that have gone through the process can help to potentially assist there.
Professor Lee, thank you. And
promote the NCP. In society, I think its values are becoming more diverse, interests are becoming more complex. Dispute will increase. It's inevitable. So if you are adversely impacted by the activities of multinational enterprises, file a complaint to the NCP. Why? It raises awareness. It will help you, it will help us, it will help the company. And also, it will help the earth move toward sustainability. So, seek help from the NCP. Is there no NCP in your country? Then ask yourself, where is the investors and the companies country came from? If that country has an NCP, anyone can seek resolution and remedy through the NCP. Making a complaint can help. It can push business to become better. It can urge countries to improve domestic laws toward international standards. It may help multinational enterprises establish a virtuous cycle of due diligence to prevent further breaches. So, seek help from the NCP. You can file any cases, actual or potential. Infringement of human rights, discrimination, harassment, sexual harassment, child labor, long working hours, and underpayment, unsafe workplace, environment adverse impact, even bribery. So fourth, so seek help from the NCP, then the NCP can be there for you. I promise, we promise. Thank you.
Yeah, I want to emphasize the significance of true preparation in the grievance process. When addressing complaints, several crucial aspects must be carefully considered. First, community understanding. The community we support must have a clear grasp of the grievance mechanism, as they are the directly affected party and play a vital role in this process. A strong understanding enables them to actively participate and raise relevant concern. And the second, strong evidence and documentation. Preparing robust evidence and true documentation is essential for effective case advocacy. Since the process of resolving cases can often take years, sometimes even decades, having well-organized and compelling evidence is crucial for strengthening arguments and supporting claims. And the third, negotiation skill. Strong negotiation skills are essential in this process. Both we, as facilitator, and the affected communities must cultivate effective communication and negotiation abilities to achieve mutual beneficial agreement. Effective negotiation can lead to better solution and help reduce tension among the parties involved.
Thank you very much for this advice. A couple of things stood out for me just very quickly before we go to the floor. We've heard that the process is relatively low cost compared to some other grievance processes that individuals or organizations might go through in monetary terms. But I think there is, what I've heard is there is a need to invest in understanding the process, both from companies and from notifiers, a resource cost, a cost at the beginning and throughout this process of really understanding the guidelines themselves, and also and how the particular complaint relates to those guidelines. So that is a cost in a way, and takes time and building up of knowledge. And the other things I really wanted to emphasize, that it is possible, there are measures in place for notifiers to remain anonymous in the confidentiality. That's really important for a lot of notifiers to know. So I wanted to just mention that again. And then I also heard mentioned the importance of face-to-face. Even though we have technology that allows us to mediate online now around the world, I think that was really, really useful to hear from Linda on the value of face-to-face when it comes to resolving some of these issues. Now we have time to go to questions. If people would like to raise their hands, we have about 10 minutes. Where do we start? We'll start over this side. We'll take a couple, and then we'll go to the panel.
Yes, my name is Hyunpi. I'm from South Korea. My organization is a member of OECD Watch. Yes, the NCP is not a law enforcement agency. However, it is also an organization run by the government and expects the victims by Korean companies to be limited with the last hope. I strongly question how much the Korean NCP made the necessary recommendation and how it contributes to the Myanmar case involved with Korean companies with connect with Myanmar military. I remember that Australian NCP also participated in the peer review of Korean NCP. The main recommendation of peer review is to actively participate multi-stakeholders in the overall NCP operation. Unfortunately, however, Korean NCP has not officially proposed or held any dialogue with trade unions and civil society in recent years. This is not implementing the core of the peer review recommendation. I would like to hear the position of the Korean NCP now. Yeah.
Okay, we'll take that one and one more.
Good morning, everyone. I'm Anusha from an indigenous community in Nepal. There are two questions that I would like to pose here. The first is, in terms of NCPs, can we bring international organizations such as ADB, which is very much involved in infrastructural projects throughout Nepal, especially when it comes to green energy and hydropower projects? Is there a space for bringing organization as such into the platform grievance mechanism that NCPs offer? And second, specifically to Linda, perhaps, when it comes to indigenous people and their rights being violated by companies and also infrastructural projects, how long perhaps does it take to address these issues? I understand it takes long, but could you perhaps, through your example, shed light on when did you start and how long do you expect it to still go on before your grievances are addressed? In terms of resources, are there any resources available that the indigenous people can tap into? Because I understand it is resource intensive and time sensitive. Therefore, based on this, I want to pose these two questions. Thank you.
Thank you. I'll pass to Linda first, and we'll go backwards. I'll pass to Professor Lee first.
It's nice to see you. It's Korean here in this conference. So I just wanted to say I am not a representative of Korea or government. So just one of a civil commissioner of Korea NCP, and just participate here in person as an expert. So, and also I'm doing a lot of activities with NGOs in Korea, like ILO cooperation and association and that kind of stuff. But I think it's when we are studying the NCP 24 years ago with guidelines, I think we didn't really know what that system was or what the OECD guideline was. So, but now I think it's our especially in Korea and before maybe even 10 years ago, we didn't aware of what was ESG or responsible business conduct or due diligence. But now everybody talked about the ESG and the RBC. So I think it's really rapidly changing the society with the people, I think. So you mentioned those kind of stuff would be, we are trying to accept more and do better working out. I think we look for. So I think it would be answer for you to that. Yeah. Thank you.
And Linda, just before I pass to you on the ADB question, on the Asian Development Bank question, I think in relation to that one, so the guidelines relate to business conduct, and businesses are often involved in ADB projects, obviously, so it would be the business dimension. But the other thing to take into consideration is the grievance mechanisms within the ADB would be an important avenue to look at as well.
Yeah, this case has been going since 1995 and continue to this day, still ongoing. Yeah, we have taken many steps to resolve this case, from state mechanism and then market mechanism, including RSPO and the OECD mechanism. Yeah, because there is no one way. We all have to try the way. Certainly, a lot of resources are needed to advocating this case, but the key word is we need to collaborate with various parties who understand the substance and have endurance to assist community and including funding. Yeah.
Thank you. A couple more questions. We'll go, there's a lady just here with dark hair, straight in the middle. You, yes.
Thank you.
It's Virginia. I didn't notice who it was.
Yeah.
Thank you, Virginia.
My name's Virginia. I work for OECD Watch, and really appreciate the reference by Sarah, because we're a global NGO network seeking to advance the effectiveness of the OECD guidelines, and we support and empower NGOs and affected communities seeking remedy for corporate-related human rights abuses through the National Contact Point system. And we really wish the NCPs wouldn't be necessary, but there are really still too many business-related human rights abuses, and the NCPs are one of the few mechanisms available to civil society to address, the violations and seek remedy. And OECD Watch is indeed tracking complaints, and we have seen more agreements coming out of the NCP complaints being filed, so that is really encouraging, I would say. Of course, there is still a lot to be done, and it could still be possible even within the realm of the recently updated OECD guidelines. So, and we will work towards that together with civil society. And we have seen good cases also in Asia. We really appreciate all the NGOs and civil society who have been trying to use this mechanism, and they provide a lot of lessons learned, and these lessons are available on OECD Watch's website. So for those seeking or thinking about using the OECD guidelines, I would encourage you to go there, because the lessons also shared by Linda, they're just so very important for us to all learn from, and the lessons learned there are really key to capture. And there's still a number of cases, actually a lot of cases who don't make it past the threshold, are still being rejected. But the encouraging thing is that there are also, it's also remedy being realized through the system, including, well, now I will name very briefly also the case, because I think it's important not to stay at this very theoretical level, but really bring it to the ground and bring it to cases, because that is what we're here for. We really want remedy for victims of human rights abuses. So, families having displaced in Cambodia to make way for a sugar plantation, they have successfully filed a complaint with the Australian NCP against ANZ Bank. Workers in DRC, have successfully been able to raise a complaint against Heineken for unfair dismissals, and also now there are very positive developments in a mediation case with the Norwegian NCP against a Norwegian telecom company who was operating in Myanmar. So I think that's inspiration for all of us. I really hope there is also set up more progressive interpretation by the NCPs on both the interpretation of the guidelines itself as well as the mandate they have, because I think a lot more is possible among a number of NCPs than is currently practiced. So I also really appreciate the highlights from the panel on good examples, how they've been able to support civil society, because I don't think it's not to be underestimated how much resource it actually costs to go through a complaint procedure. And we very much appreciate that there are no costs involved with the mediation itself, but just the cost to prepare for the complaint, the evidence threshold, collecting that, going through mediation, and the time it takes. And Linda, yeah, your case has been going on for a very long time and it's still not resolved, at least not to the level that's of the satisfaction of the people on the ground, is something that yeah, we need to work on. So I hope we as community and also the NCPs can work together to address also the power imbalance between companies and civil society, and we as OSDOs have developed a short guide to help complainants, and we're also very much available for any advice. Yeah, to the panel, I don't want to take time with a question,
we're out of time. Yeah.
I'll keep it at this.
Thank you so much, Virginia. That's really helpful. We are unfortunately out of time because it's just a 1-hour session, but please come and ask us questions directly. We'll be very happy to answer those after the session. Sorry that we've run out of time. And I wanted to just very quickly say, don't hesitate to contact NCPs because, yes, the submission of a complaint process is a full process, but they also can receive inquiries. You can ask questions. So ask questions of NCPs using contact details. There's an OECD booth today and tomorrow. If you have questions about the NCP network and OECD, please come and see us there. And there's also another session if you're interested in hearing more about NCPs on a specific topic, seeking remedy in relation to sport and human rights. There's a session this afternoon at 2:30 p.m. in conference room 3. Thank you so much to the panel, to our speakers, to Linda, Professor Lee and Sarah. It was really very much appreciated to hear from you.